just hanging out with us for a little while as we get to explore my favorite topics of compliance and health law. Today, I am so privileged and humbled to be joined by two of really my favorite lawyers that I get to work with on a pretty consistent basis. First is Gina Singleton. She's a partner at Brennan, Manna, and Diamond. She's located in Ohio. She has been a lifelong defense attorney in white collar matters. She brings a wealth of experience and tremendous insight into a lot of the administrative issues, into regulatory compliance for physician groups, hospitals, and especially laboratories. And that's important because we're going to explore some of the laboratory guidance a little bit later on in this podcast. And then I'm also joined by another fantastic attorney who wised up in his career as a federal prosecutor and decided to leave the dark side and come to the light. As they used to say in Poltergeist, come to the light, Carol Ann. Colin Callahan of Flannery Gergalis. He's a partner. They are a boutique consultancy for white collar crime. And again, obviously having a former federal prosecutor turned defense counsel is going to give us a lot of opportunity to, explore the mindset of a prosecutor on these different scenarios that we talk about and how he uses that to help in aiding his defense of his clients in some of these targeted issues related to the False Claims Act, the healthcare fraud statute, and some of the other fun things that we'll talk about with the AKS and Stark and DEA regulations. So, again, welcome to Colin Callahan and Gina Singleton. Thank you both so much for being here today.
Thanks, Sean.
Yeah, thanks for having us, Sean. Excited to chat with you.
Yeah. So, a lot going on. I know Colin just came back from a nice respite, had a little family vacation with some friends, and did a little rock climbing, a little whitewater rafting, and just some R&R. And he's looking nice and refreshed and ready to go. And Gina's always looking great, but I know she has been slammed because she's on a lot of the same emails that I'm on for a couple of our clients. So I don't know how she looks good, and I look like I've aged 25 years over the last week. So everything is just as it's supposed to be. That's why they say I have a face for radio. All right, so I want to get started this morning by talking about really the intersection of prevention and prosecution and enforcement, right? I don't think either of you would disagree with me, at least I hope you wouldn't, that, a lot of folks said 2022 was the year of the audit. And I tell people, anytime you say something is the year of, that means it's going to stop and you're going to revert back to the way things were prior to whatever it was that caused that ramp up or that wind up, if you will. I don't believe that 2022 was the year of anything. I believe that it was the entrance into a new era of aggressive or over aggressive investigations, targeted audits by a variety of contracted bounty hunters to the federal government, if you will, and overzealous prosecutions. So I'll stop there before I go any further, and I'll open the floor. Gina, ladies first. Let me get your thoughts on, whether you think I'm right on the fact that we've entered into a new era of these over aggressive investigations and overzealous prosecutions.
Sean, I think you're absolutely right that the audits and enforcement activities are not going anywhere. In fact, we've seen over time that the funding for the federal government's enforcement activities has continued to increase, and I don't see them cutting budgets on those activities anytime soon. And maybe it's important for our listeners to remember, well, why is the government so focused on enforcement? And I think the primary reason is that these are taxpayer dollars that are funding government benefit programs, and they have an obligation to make sure that those dollars are being used wisely. On the provider side, which is where I spend all of my time, I'm not a litigator. I'll be very upfront about that. So I spend a lot of time on the preventive measures. I think we can't underestimate the power and the value of using preventative measures to guard against enforcement activities from the standpoint of making sure we're in compliance. Those compliance plans, use of the voluntary refund and self-disclosure protocols, making sure that you're doing risk assessments on a regular basis, having a good, solid compliance officer who's very active in making sure that you've created a culture of compliance with your entire organization. You can't underestimate the power of those. And I think that those will be your primary tools if you ever are hit with an audit or an enforcement action. But to your original point, Sean, I don't think it's going to slow down anytime soon.
Yeah. And you know, I know you can say that with great confidence because of the number of cases that are coming through the door on a daily basis to your firm. Colin, you know, I'll ask you I'll pose the same question to you, but I want to get maybe a little different slant on it, right? So if you were still a prosecutor today and you had the repeal of things like the brand memo or the session memo, to where now you had the ability to again put the arrows back in your quiver to be able to say you could use these quasi regulations or other agency guidance documents to go after providers for potential fraud, waste, or abuse, you know, would the green light in your mind be, hey, fair game, let's go? And given the, and I'm sorry, and the other part to that is, given the recoveries tied to the public health emergency and the continued inquiries into providers from the PHE and those services that were billed.
Yeah, so let me break that into a couple chunks because I think it's all related, and what you know, the way you put them together makes sense. But I'm a simple guy, so I got to break them into pieces to answer. You know, I think you're certainly right in terms of really, if you're graphing this out, the focus on and the resources spent concerning enforcement are only going to increase further over time, and you know, a big piece of that is because we're only spending more money as a country on healthcare as well, right? You know, we have aging populations across the country. You know, the amount of sort of Medicare spending, assuming the program remains solvent into the future, is you know, only going to, you know, increase as more and more folks are sort of aging into those programs. You know, we've seen continued expansion of Medicaid programs, you know, as recently as this year, you know, based on some of the incentives that originally were rolled out with the Affordable Care Act. So, you know, where the dollars increase, and then you go and you look at sort of regulators, law enforcement, and, you know, where I used to work, the U.S. Attorney's Office, you're going to follow those dollars. And, you know, we can debate whether or not that's wise, whether it's the best use of resources. And ultimately, I think whether or not individual investigations make sense, you know, have to be looked at on their own individual merits. But the enforcement's going to follow the dollars, and there's just no question about that. And so it's not going to stop. The importance of compliance, you know, the importance of sort of the things that, you know, you do, Sean, and that Gina does to try and help folks on the front end, you know, avoid problems, is only going to become more important. All right, so that's that piece of it for me, right?
Right.
You know, the sub-regulatory guidance piece, and sort of like what can you use if you're a prosecutor to put together a case? What is fair game to sort of consider, especially on issues impacting Sienter, for example? You know, we've been having a debate about that sort of, frankly, within the Department of Justice and without it for more than 10 years now. And, you know, I think that there can be fair uses of that type of information as evidence. I'm a defense lawyer these days, obviously, right? So, but I'm not going to go so far as to say there's not circumstances where that is factually relevant. But I think that needs to be the way that it's used sparingly, if ever. And, you know, what we can't ever see again, and what we should never see again, is circumstances where somebody is being pursued either criminally or under, you know, civil fraud sort of charges for having violated not a statute, not a regulation that's gone through sort of the proper channels, but what is only sub-regulatory guidance, right? That's what really gets me excised. And so, if you have a guidance document out there that on a particular case was reviewed by somebody and it's indicia of truly a crime having been committed on a clear regulation and statute, well, okay, you can take that on and maybe that's appropriate. The worry, obviously, as administration changes and views change on these things, is that we revert back to a circumstance where somebody is literally having their liberty placed at risk for something that never even went through a notice and comment period.
So, what and I love when you guys use terms that are they're legal jargon terms, right?
Yeah.
The scienter, right? So I have a ton of lawyers that listen to this, and they're going to know exactly what you're talking about. But for the non-attorneys, right, the compliance officers, the auditors, the coders, the practice managers, the physicians, the standard that you're talking about is an individual under that standard having intent or knowledge of wrongdoing, right? So basically, when a person has knowledge of the wrongness of an act or an event prior to committing it, that's what you're talking about from the you pronounce it as scienter standard, right?
Yeah,
So
yeah, that's right. It's the requisite guilty mind, right? It's what you have to have been holding within your head that's animating your actions at the moment that you do something, and that's oftentimes the dividing line between hey, I made a mistake in a complicated regulated field versus I committed fraud.
right, and so that's the difference between erroneous and fraudulent, really, right? And Gina, I think it's important for our listeners to also comprehend that when we use terms like intent or knowledge, that they have very specific meanings and they are tied directly to different laws, if you will. So, for an example, the False Claims Act, right? It is not an intent-based act. It is based on knowledge, right?
Right.
Knowingly submitting claims that are false. Let me have you talk about that. The three components to the False Claims Act, if you would.
Sure. So, Sean, I think what's really important to remember about intent is the standard isn't just that you actually knew, it's known or should have known. So you can't just turn a blind eye and say, well, I wasn't involved with that, or I didn't intend to do that. And I will tell you, I think the intent-based arguments are tough arguments to make. And maybe Colin has better insight on this, but I think it's very difficult to stand up in front of federal prosecutors and say, well, that's not what I intended. It may look really bad and all these facts are against me, but that wasn't what I intended. So I guess what we advise our clients, whether it be False Claims Act violations, anti-kickback statute violations, ECRA violations, that you can't rely on just being able to say, well, I didn't intend to harm anybody. You really have to be able to back up those arguments with, hey, these are the steps we took to make sure that we weren't going to be in violation of the law, that there would be no misunderstanding as to what we knew or should have known, that everything we did was very intentional, and our intentional conduct was always geared towards an intent of compliance. And I think that's really important.
Yeah. And am I correct, Colin, in saying that when we're talking about intent, right, we're talking about the healthcare fraud statute, because that, under, what is it, 18 USC 1347 or 1349, that's an intent to commit a scheme or an artifice against the government, as opposed to under 31 USC 3729, that's the False Claims Act, where it says knowingly. And that's the difference between it, right? The False Claims Act is a knowledge-based act, right? With deliberate ignorance, meaning gross negligence or reckless disregard, burying your head in the sand, or knowledge of the falsity of the claims.
Yeah, they're different standards. You're absolutely right in the way that they're defined. And Sean, as you and I have talked about exactly the operation of sort of how intent works in the False Claims Act world, it's a live issue right now, right? So in fact, I believe Tuesday of next week, argument is being held in front
I think Colin froze just a little bit. There may be something on his end with the internet.
On the operation of some of these issues of the False Claims Act doesn't require that it generally is going to if you're dealing with criminal fraud stat. Am I still coming through? Okay, Sean, by the way.
Hey, Colin, I think we're having a little bit of difficulty with your connection. Gina, are you okay?
I lost the
You're
screen.
hearing me okay, right?
I'm here, yes.
Okay. So I think what Colin was talking about is come next week, we're going to see the beginning arguments at the Supreme Court. I think it's the super value.
I think
case.
I'm back. If you guys can hear.
And basically they're examining the knowledge-based intent
Yeah, I think that's right.
Of this case and whether or not an individual could be held responsible for knowingly violating a convoluted law, statute, act, regulation, whatever it may be, or if they could be found guilty or held liable for making a mistake of a convoluted law. Gina, is that the understanding that I have? Is that correct?
That's my understanding as well. And it'll be really interesting to see how this plays out because it'll have long-lasting implications. I mean, the court's decision in this case is going to affect. Oh, great. Yeah, Colin, we'll let you comment here. I was just wrapping up by saying I think that this case will have long-lasting implications as far as how enforcement activity proceeds and what is acceptable, I guess, on the enforcement side.
Yeah. All right. Colin, do we have you back with us?
I think we do. Sorry about that.
That's okay. All right. So hopefully, I know you were giving us some guidance on what's going on at the Supreme Court next week. I know yours would have been much more eloquent than probably my explanation of it, but I hope I did it a little bit of justice. Let's move into another topic. Well, you know what? Before we do, Gina, you brought up something that I think is a really valid point, and it's super important. And for those of you that listen to all of the different episodes of the Compliance Guy, I had an opportunity to hang out with my good friend Kenneth Polite, who's the Assistant Attorney General, and he's over the criminal division at Maine Justice. And one of the things that we got to explore was how the DOJ really looks at an organization creating a culture of compliance. And you used that term not too long ago when you were, giving some explanations about the importance of preventative measures in an organization. Can you, from an attorney's perspective, right? I know what I think from a compliance officer's perspective, but from an attorney's perspective, could you share with our audience what you would determine to be a culture of compliance? And then, Colin, I'm going to ask you the same question.
Sure. So I think most of our healthcare organizations are familiar that the OIG has guidance out there as far as what needs to be part of your corporate compliance plan. And it has all the different elements you're supposed to meet. So on the written policy piece, I mean, that's obviously a must. You have to have that written policy and procedure manual, and it should meet all of the elements that are in the OIG's guidance. However, that's not enough by itself. We've had many times where people have said, oh, I found this form online and we put our name on it and put it on the shelf and we have a compliance plan. And I said, well, no, you have a form that has your name on it. You don't have an active compliance plan if that's all you've done with it. So I think from the legal perspective, yes, one of the baselines is you have to have written policies and procedures. You have to have a compliance officer appointed and meet all those requirements under the OIG's compliance program guidelines. However, it doesn't help if nobody knows what's in it, if nobody actually follows it. So after you have your policies and procedures, you still have to educate all of your team members from your newest volunteer all the way up to the highest paid executive and your board members. Everybody in the organization needs training and education on an annual basis to know what's in that compliance plan. On top of that, you need to have a team that is led by your compliance officer that is constantly looking back at the compliance plan, making sure that they're doing risk assessments and evaluating if the policies are being followed, that people actually understand the policies. If there is an issue, that corrective action happens after an in-depth investigation. And that if after corrective action occurs, that you go back and revise those policies and procedures again. So I think, Sean, you termed the coin quite a while ago. This is a living and breathing document. The idea that your policy and procedure manual is kind of the foundation for your compliance program. It sets the rules, but it can't just be a stagnant document. It has to be something that people are very familiar with, they're constantly referring back to, and you're constantly updating. And that you're testing yourself, you're testing your system to make sure that it's actually the compliance program is actually working.
That's a great explanation, Colin. I want to ask you the same question, but I want to put a little bit of a spin onto it because you are a litigator. So when we define culture of compliance for a jury, right? How do you talk about culture of compliance to a jury? What does that mean to you from, going from being somebody's punchline to being an actual tagline, if you will, in a federal case?
Yeah. So we were talking about intent earlier, right? And I think that if you're like me and you represent individuals who have been, charged with generally federal crimes, one of the ways that you can try and show rather than just tell that somebody, even if they got some things wrong, didn't do it intentionally, is to actually try and sort of highlight to whoever your audience is, maybe in the first instance, prosecutors who you're trying to get to decline to bring a criminal case, or ultimately the fact finder, whether it be a jury or a judge, if you're unsuccessful in that first venture. And, talking about good faith efforts to be in compliance is one of the good ways that I think that you can do that. I mean, we all work in healthcare. A lot of this stuff is complicated. If you have a billing fraud case, it is absolutely possible to have made mistakes, be in a position where you've got a client who is willing to repay monies because of those mistakes, but where they've got a good story to tell a jury that they were just that, they were mistakes, right? And so, if you can put a witness up on a stand, if you can introduce through various sort of, evidentiary sources, look, here is what this owner of the company, who has now been charged with healthcare fraud, did, and the ways in which he or she went above and beyond to try and make sure that they never ended up in a place like this, right? They had a competent, experienced, billing team in place. They had a real compliance officer and a compliance team that grew as the company grew, right? That was, not just viewed as a cost suck, for purposes of the operations of the business, to the extent that you can show that, right? Here are the yearly trainings that, were done, to try and make sure that things, went the right way. Here's the audit history that, the relevant sort of entity and individuals went through. And here are the changes that they made after they went through sort of, the relevant sort of audits. So, I think all of those things can be relevant to in the right case and presented, even to a fact finder to try and show, that the requisite criminal intent isn't there, even in cases where perhaps it is even undisputed that the billing was mistaken in the first place. And I can tell you, I have several cases that look like they're going to be trial cases right now that really are those kinds of cases. They're sort of what used to be more of a rare breed, where it's a straight billing fraud case. And, in many instances, we may dicker around the edges about was something a mistake or wasn't it? But, there were some billing problems. They could have been addressed through the administrative process like they normally are. Instead, we've got a criminal case. And so, I think a jury will hear about those things.
Yeah. Last year I was looking just yesterday at the cases that I did. And last year I had 18 federal cases. And of the 18, 12 of them, were settlement agreements or they were deferred prosecution agreements, or they were outright the government just saying, we're no longer going to pursue this. And I think it was about 50% of the cases where, you know, the attorneys I worked with utilized a report that I wrote to be able to compel the prosecution not to go forward because there was a misapplication of a guideline, a regulation.
Right.
You know, one of the big arguments that we made was that, you know, the reliance on a local coverage determination by a Medicare administrative contractor is not law, right?
Mm-hmm.
It's a guidance document, and it means just that. It's a position that the carrier has taken based on what they believe to be a best practice. And best practice doesn't rise to the level of a law, right? If you want to use a law, you know, use a law, use a regulation, something that's been promulgated into the law. But I love what you said about, and I was going to say, of the 6 remaining cases that actually went to trial, we got full acquittals at trial. $680 million we were able to preserve for our clients last year. That's a real number, 680 million. And you can look these cases up, you know, United States v. Bothra, Lewis et al., United States v. Leslie Pompey, United States v. Jeffrey Campbell, United States v. Brian August, United States v. Reyes Vizcaíno. I mean, these are all cases that had Bothra alone was $450 million. So, you know, it's really interesting to see a lot of these cases that years ago never would have found their way to a courtroom somehow found their way. But I love what you said about good faith, right?
Mm-hmm.
And, you know, you both know me. I have a lot of friends who are prosecutors or former prosecutors. And would you say this is true, Colin, as a former prosecutor, that a prosecutor is less likely to bring a case to trial for fear of an inability to convince a jury beyond a reasonable doubt that somebody acted with intent if they have an effective compliance program in place, meaning that, you know, they have a compliance officer. It's a bona fide position. It's not, to use your term, you know, a cost suck. And I think that's a great term. I'm gonna steal that from you. You know, that they have effective policies and procedures. To Gina's point, right? That they didn't just go out onto the internet and find some document and throw their name on it, but they actually are actively engaged in monitoring and auditing their policies and procedures and revising them to remain relevant. Is it fair to say that a prosecutor would hesitate to bring a case?
Yeah, it's just such an important piece of any discussion that you're going to have where you're trying to fend off charges. And I think it's true in at least 2 different ways. You know, I think if you're in front of a prosecutor who has an open investigation and, you know, you're making a formal or an informal pitch for a declination, you know, if you're walking through your slide deck and you're able to really talk in concrete terms about, you know, everything that was in place on the front end, and even while perhaps there was an issue that needed to be correct that, you know, in our view doesn't rise to the level of a criminal violation, it really was an outlier. And, you know, these are sort of an entity and a series of individuals that take compliance seriously and you know, we're operating in good faith. I think there's a lot of prosecutors out there who are gonna, not just because they're worried about winning a case at trial, you know, they'll give you a fair hearing, right? And they'll say, you know what, all right, I'm convinced, right? These are good people who were trying. Something slipped through. There's other tools in the tool belt to address it. I'm gonna let them go, maybe, right? And so those are happy instances.
Yep.
You know, more cynically, but it's also accurate. And in other circumstances, folks may not walk through those mental gymnastics, but they may say, "Yeah, that's going to play pretty well in front of a jury, and I don't want to lose. So again, I'm gonna." Right? But I think the third piece that's also important is, you know, nobody that is in law enforcement, you know, wants to let somebody skate for what they think was at least a problem on some level, where they think there's a real fear that it's going to be repeated or that something's going to be worse later on. And so, one of the things I always want to sort of hammer home where you're trying to fend off charges is, look, here's everything they did before, and it was actually pretty darn good for all of these reasons. But now look at what it looks like going forward, right? Because we brought in Gina Singleton and her team to make what was a B compliance environment. Now it's an A+ compliance environment, right? And I say that because Gina's on here, but I also say that because I hired Gina, right? I mean, because you want somebody with gravitas and who regulators are going to respect. It's actually important. And so where you can point to, bringing in folks to improve what may already have been pretty good, and calm folks' fears about, am I going to see these same folks 18 months from now? I think that's really important as well.
That was very kind, Colin. I hire you too.
It has the virtue of being true.
And there's no violation of the anti-kickback statute.
There you go.
Right. Sean, I was going to ask you a question. I don't know if I'm allowed to do that on a podcast.
Of course.
I'm going to. On the 6 cases where you got acquittals, I guess I have 2 questions. First, is there a common thread as to why they all got to trial in the first place? And second, is there a common thread as to how they all ended up as acquittals?
Yeah. Yes to both. And I always get nervous when one of the guests says, I'm going to ask you a question, because these are unscripted, these podcasts. This is 3 friends sitting down at a coffee shop or later in the day at a bar and having a conversation. So yes, there is a common thread to these cases. They all centered around coding and billing fraud, or allegations of coding and billing fraud, the utilization of high-level evaluation and management services, level 4s, some level 5s, services in several of these cases were tied to spinal injections, pain injections, the prescribing of opiates. The Substance Control Act is obviously, even with Ruan, we're still seeing cases being brought, which I think there's a need to educate some of these prosecutors really on what it means to have knowledge of prescribing outside of normal standards. But the common thread to why all of these were acquittals, it was the difference between having a career compliance professional who was able to take what the government portrayed as PhD level scenarios that were so complex that you had to have a PhD to understand it, to where I was able to come in and say to the jury and look them square in the face, just like I'm talking to you right now, these issues are not that complex. The reason why the prosecution believes that they're complex is because they got the wrong expert to help them understand really what transpired. And to help them understand, one of the big arguments that I've seen from prosecutors when it comes to 99214s and 99213s or 215s is that they are relying on the typical times. And this is pre-2021. So keep that in mind, to where they're saying, in order for a physician to support a 99214, they have to spend 25 minutes face-to-face with the patient. Well, no, that's not what it says. And the common thread is that none of these prosecutors in the case were educated to the point, or hired an expert who is educated to the point to go into chapters 3 or 6 or 12 of the Medicare Program Integrity Manual and find a specific section that says time is an ancillary aspect of an evaluation and management service, and only applies in the event that greater than 50% of the total face-to-face time was dominated by counseling and or coordination of care, which means the remaining aspects have to be dominated by either the history, exam, and medical decision-making, 2 of those 3. And when you explain it to the jury in very simple language and you show them the actual citations from Medicare on a big screen like they have in these courtrooms, it becomes Mount Everest for a prosecutor to try to scale, to rein the jury back into believing that, their side of the story was right. And in the Bothra case, it was, I think, 54 counts of indictment against each provider, and the prosecutors had to sit there as the jury read off not guilty for every single one of those counts. And Colin, as a former prosecutor, that's pretty painful.
That's I think the term of art for that is not a good day.
Yeah, not a good day. Well, I'll be nice about what I'm going to say. In the Leslie Pompey case, it was 36 counts of fraud, all 36 counts overturned. Same thing in the remaining cases. So yeah, there was a common thread. And for me, the common thread, and I think the other thing is most prosecutors may only litigate a case in a courtroom once or twice a year now. It's not like the Perry Masons that you see on TV. It's not like the old days. And, I don't think a lot of the young prosecutors today, and Colin, you correct me if I'm overstepping or I'm wrong here. I don't think their predecessors educated them enough in the way that they were educated by their predecessors, because most of them are given a book on litigation and wound up and told to go and, put on your cape and fight crime.
Right. Well, we live in kind of an age where trials in most aspects of litigation are less and less frequent. You're spot on. And so when you come from that kind of a background, you have less chance to sort of test yourself in some of those ways. And one of the areas where I've seen it, and I know we're going to talk about sort of lab stuff in a second here, but when I joined the U.S. Attorney's Office back when I still had brown hair in Pittsburgh, we had a criminal chief who had, a healthy skepticism of the jury appeal of kickback cases. He had a pretty high standard for what he thought, should be a criminal kickback case. And that's in part because I think there was a humility there that came from having been in a lot of battles in the trenches and having understood, like, if it's a pure kickback case, so not a kickback case where, services weren't even provided, not a kickback case where, you had overutilization that, was to the detriment of patient safety or something like that. Just a pure kickback case, but where services were provided and were actually things of value. It was going to be really hard for an agent to talk him into taking that case criminally, because the guy had tried a million cases. Yep. He knew in his sort of, head, here's where I think justice requires me to bring this kind of case versus it doesn't. And by the way, I might get my butt kicked because the jury's not going to actually like this, in some ways, almost irrespective of the legal technicalities. Yep. And I do think we're in an era right now where that's probably a less common way of thinking about and approaching charging decisions.
I agree with you. And that's one of the things I love about Kenneth Polite, is that he is old school and he's looking to bring a sense of stability back to the criminal division at Main Justice. But, Gina, I want to come to you for a minute before we move into our last topic, which is telehealth and the expiration of the PHE. You brought up something earlier in our conversation about the self-reporting of issues, right? And there's two different types of self-reporting, right? You have the voluntary refund process, and then you have the OIG self-reporting, or OIG self-disclosure protocol, if you will.
Right.
Can you quickly talk about the difference between those and why those are such critical tools in a compliance officer's tool belt?
Sure. So I guess both deal with the fact that there's a very baseline rule that says that if you are paid for something that wasn't appropriate, you have to pay the money back. You don't get to say, oh, I'll push it under the rug and see if anyone catches me. There is a requirement that you pay the money back proactively. So the voluntary refund process is, I think of it as, that's when you make your run-of-the-mill billing mistakes. Mistakes happen. We're all human. There's a process that the federal government has set up to allow you to make those voluntary refunds within the allotted time frame so that you can say that you repaid the money on a timely basis. The OIG self-disclosure protocol is for those situations where maybe it wasn't so much a mistake. Maybe it could be construed as fraud or other sorts of wrongdoing. And it's a way for you to self-disclose. And the big key is that it stops the clock. There's a 60-day window to repay overpayments. So it will stop the clock to allow you to continue working through the situation with your investigation and repayments and all of that. But it also will help provide shore up your defenses if there turns out that there's a problem. So they're both very important, but the baseline rule really is, look, this is healthcare. If you did something wrong, you got to repay the money, whether it is a mistake or whether it was more than a mistake and something more along the intentional lines.
And is it fair to say, and I'm going totally from memory here, so if somebody calls me out on this, it's okay. I think it's section 6405 of the Affordable Care Act, which talks about the 60-day rule.
Correct.
Is it, so I'm actually correct, thank God. Okay, so is it fair to say that under the 60-day rule, if somebody fails to make a voluntary refund of monies that they know they received in error, that could constitute a reverse false claim because it takes into consideration the mindset of the person at the time the act or potential crime was committed?
I think you've created a much bigger problem if you don't follow the refund protocol, whichever one's appropriate for your situation. Because it's pretty black and white. There is a requirement to repay if you weren't supposed to get paid in the first place.
And Colin, last question on this, and then we'll move into the telehealth. A lot of practices say, Sean, OIG compliance is voluntary, right? It's not like HIPAA, right? And it's HIPAA with 2 A's, not 2 P's. Okay. It's not like HIPAA where it's like public law 104-191, right? This is voluntary, but isn't the fact really that OIG compliance is a requirement, and it's been a requirement since 2010 under the Affordable Care Act, where it says any physician who renders care to Medicare or Medicaid beneficiaries and bills the system for those services is required to have a compliance program. Is that an accurate statement?
Oh yeah. There's, I mean, that's certainly accurate, right? But it's, if it was against the law to jump out of an airplane without a parachute on, I suppose that's certainly one good reason why you shouldn't do it. But there's a few others that come along with it, I guess, would be my analogy, right? So yes, I mean, like what you're saying, certainly spot on in a vacuum, but we're at a point with the dollar values again that exist in the healthcare industry, which aren't stopping anytime soon, and all the regulatory scrutiny that comes with them. Anybody that's an owner of an entity, anybody that is operating in this field, that doesn't realize that it is in their own interest to not just have a compliance program to check that box, right? But to protect themselves and literally their own, potential liberty, in addition to pecuniary interests, is crazy. Is really what
and I
it comes down to.
empathize with providers. I really do. I empathize with them. I sympathize with them. I had a provider just the other day say to me, Sean, listen, I know what you're telling me is accurate. I know how important this stuff is, but here's the deal. Inflation is killing my business.
Sure.
Decreased reimbursements and government scrutiny by these auditors who are continuously clawing back money through automated audits is killing my practice, because I'm tying all my capital up in fighting these bogus, and those were his words, these bogus demands for refunds. And he said, Sean, here's the deal. I just can't afford to put a robust compliance program into place for my organization at this time. So I'm going to roll the dice. And if the government comes and they tell me that I owe them a big chunk of money, I'm just going to file bankruptcy and shut down. And I'm trying to explain to the provider, It doesn't work that way. You may want to file bankruptcy, but there's still the potential for criminal damages and criminal charges and CMPLs and all these other things that tie into it. So don't think that if you decide, I'm going to abandon my compliance plan and I'm just going to roll the dice and take the chances, and if I get caught, I'm just going to declare bankruptcy and all my problems go away. Am I right, Gina? It doesn't just go away because you declare bankruptcy.
Right. And Sean, I think it's important. The bankruptcy may take care of some of your business debt issues. It will not keep you out of jail.
Yeah.
And that's a bigger problem than whether you have debt or not.
Yeah, it doesn't resolve your civil or criminal liabilities to the government, right?
Right. Well, and if you're a provider, the collateral consequences of all of this are enormous too, right? I mean, I talk to a lot of people who are having the worst day of their life when they call me, right? And then sometimes they realize that's not the worst day because there's the day after that. But a lot of people go into these decision-making processes like what you just said, where I think they think, well, if I do X, Y, or Z, like somebody's telling me as best practices, I'm going to go bankrupt anyway. So, hey, worst case scenario, I go bankrupt later, or my business fails later, I'll roll the dice. And it's just not accurate, right? I mean, it's one thing to try and rebuild, with a new business after you've addressed sort of like corporate debt issues. It's a heck of another one where even if you don't go to jail, if you're now excluded,
That's right.
if you've now had the licensing board come and yank your ticket as a result of things that you may directly not have even done, right? But because you had a vendor relationship with somebody that was doing whatever the monetary making fad of the day was, that you in your somewhat economic desperation said, okay, I guess we could do that, and didn't do your diligence on it. Starting over looks a lot more difficult now, right?
I would also add, it's important to remember we've unfortunately had clients who have tried this before they came to us with the bankruptcy approach. And my bankruptcy partners will be the first to tell you that generally, if you are assessed penalties and fines or damages by the federal or state government, those are not dischargeable in bankruptcy. So sure, your loan from the bank may get mitigated or your credit cards may get wiped out, but the government's damages are still sitting there and they're not going away.
The U.S. Treasury Department is not going to say, okay, Sean, we understand you wrote off, you're writing it all off under bankruptcy, so we're just going to discharge your $1 million of liability to the federal government. It doesn't work that way. And providers, this is the difference. And I can't say this enough. This is the difference between having highly skilled healthcare centered attorneys versus having a general practitioner who says, yeah, I do some healthcare stuff here and there. I think we'll be okay. No, you're not. It's like taking your car to, Circuit City for an oil change. We don't even have Circuit Cities anymore. It's like Best Buy, isn't it? Shows you how I still live in the 80s. Okay. I want to move on.
I loved Circuit City back in the day, just to be clear.
Circuit City was phenomenal, wasn't it?
That was fantastic.
Oh my God. That's where I built my first sound system for my house that my grandparents were like, okay, either it goes or you go. And you go was not the car. It was you go. All right. Last topic of the day. And again, this is why I love having, folks like yourself, Colin and Gina, on this podcast, because we can dive so deep into the, just the minuscule aspects of healthcare compliance, healthcare law and regulations, and all the little facets that sometimes general practitioners of the law who dabble in healthcare miss completely, or give horrific advice that costs their clients even more. All right. Last topic of the day in the last 10 minutes that we'll spend together. Telehealth. The expiration of the public health emergency. And I will say this, no matter how much people talk about telehealth, we still find that there's a need to talk about telehealth because it's a huge problem. So I want to open up this part of the conversation to Colin and to Gina. on how you want to explore telehealth during the public health emergency. So whichever one of you wants to go first, take it.
I'll just jump in. I think there are some key things that have been really interesting to watch unfold regarding telehealth. One, it has been a primary topic on the OIG's work plan for audits. I think they had 6 or 8 audits in the past year alone. Now, the good thing is I think a lot of those audits actually came out pretty positive as far as lower findings of fraud than they thought there would be. So that was good. But I don't think that those audits are going away at all. I've had people say to me, well, telehealth is going to fizzle out now that the pandemic has been declared over. I'm like, no, I don't think telehealth's going anywhere. If anything, I think it will continue to grow. And because of that, I think that it will continue to be on the OIG's work plan. So I would say watch out for that. With the expiration of the PHE, it's important to remember that there were certain waivers in place that are going away. On the billing side, there will now be times when in-person visits will be required periodically. So you really have to know what business model you have using telehealth and how do the billing rules in the non-PHE world apply to that. We have a large behavioral health client. There is a fairly new behavioral health law at the federal level that requires an in-person visit every year in order to do telehealth under Medicare for psych services.
And Gina, I don't mean to interrupt, but isn't the law also on the book that prior to a new patient having any type of opioid or narcotic, or I think it's a Schedule 2 through Schedule 5 drug prescribed to them, they have to first have an in-person visit prior to them being able to have a prescription written via telehealth? Is that accurate?
Correct, Sean. That is accurate. And in fact, that's a really good point, because another thing that's happening now that the PHE is ending, the DEA has come out with proposed rules about prescribing via telehealth. So it's really important to pay attention to those rules. They're not finalized yet, but they're coming. And the proposed rules have already been published and put out for comment. Along with that, each state has developed their own telehealth landscape. I know in Ohio, the Ohio Medical Board just released its new telehealth rules back in, I think, the end of February. So you have to be able to match up both the federal and the state rules governing telehealth for both scope of practice as well as reimbursement. The other thing that's happening with the expiration of the PHE is that there are licensure waivers that are going away. So if your state had a situation where they were allowing out-of-state providers to see patients via telehealth more easily during the pandemic, well, those are going away in a lot of states if they haven't gone away already. The other thing that's happened that was just announced is that the Office of Civil Rights, the OCR, under HHS, governs HIPAA, and their enforcement discretion is coming to an end. So you are going to be bound by all of the HIPAA rules regarding telehealth to their full extent again. Now, they've given us 90 days, and there's a 90-day window to make sure you're in compliance before they're going to go back to enforcement. But those are all things that are happening because the PHE is ending. So the landscape's going to continue to shift, but I think it's really important to pay attention. It is not going away.
I agree with you 110%. If there's a 10% above 100 that you could agree with. Yeah, telehealth service. If you look at telehealth prior to the public health emergency, I think it was like a single digit for the number of beneficiaries that actually engaged in telehealth. And during the public health emergency, Medicare beneficiaries, I think, was somewhere around 86% of all Medicare beneficiaries. Look, anytime you see significant spikes in utilization of a service that has rarely been used, you know there's going to be bad actors, but not even bad actors. There's going to be misapplication of the guidelines. And I think especially in the beginning of the public health emergency, I was appointed to one of the governor's task forces about 6 months into the public health emergency. And when we started talking about the guidelines related to telehealth services, I'll never forget, this specific governor said, "What are the guidelines?" And I said, "Do you want to know the guidelines today, or the guidelines yesterday, or the guidelines last week, or the guidelines that are being proposed for 2 weeks from now?" And the governor was like, "What are you talking about?" And I had to go through and explain how many iterations just in the last 2 months we had seen of the telehealth regulations. I mean, we had the American Medical Association who had to do a complete 180 because one of their guidance documents that they published was completely off from what CMS guidance was. The commercial payers, right? You both remember this. It was the Wild West. We had providers we had payers all over the place. And not only did you have payers all over the place, it depended on what plan you were participating with as to whether or not you could do it this way, that way, or whether you could do telehealth services at all. Right. So I agree with you 100%. Telehealth services are going to be a mainstay because of the convenience factor, but it's going to be critical for providers rendering those services to have firm understanding and education as it relates to these services.
Yeah. And, Sean, when we were talking about a living, breathing compliance program before, I mean, this is like just a small but concrete example of kind of what you're talking about, right? I mean, we're in a transition period with what the regulatory landscape is going to be with this stuff. It's going to vary state to state, and we don't know exactly where things are going to end up. And so you gotta, if you're running a physician practice, if you're running a small to medium sized, health system, whatever the case may be, you need to have somebody knowledgeable providing real-time advice on an ongoing basis. So I just think it's a good example of that. And then the other thing that I would just add on telehealth broadly from a enforcement perspective, I think there is a growing recognition that, telehealth can be good. And so that's a positive because it can be, right? I think it can be a really powerful change agent, especially in more rural areas that have had access issues and the like. But there remains a really deep-seated suspicion and distrust of telehealth, in the law enforcement community. And in fairness, there's some good reasons for that, right? I mean, some of the largest and most egregious fraud cases that we've seen over the last couple of years have relied in significant amounts on telehealth groups that really were not close to the line. They were just unscrupulous, kind of brazen entities. But it's not fair for everybody to get tarred with sort of that broadly. And so I think that's kind of what you're up against and why it's particularly important to dot I's and cross T's as we move forward with this stuff under what will be evolving rules, because those egregious brazen examples of the use of telehealth are what an awful lot of strike force prosecutors and, state AG sort of Mafuku folks and everybody else sort of has in mind as they're thinking about this stuff.
Yeah, and I'll end our podcast on this. The first time I had somebody say Mafuku, I thought they were talking about my mother. Just a stupid thing. All right. Colin, Gina, I cannot tell you how much I've thoroughly enjoyed this episode with you both. I'm so grateful, Gina, that you reached out and said, hey, would love to do a podcast with Colin and you and, talk about some really critical topics. And I think you guys hit a home run on the topics. I think you hit a home run on your explanations of these different situations that are going on. And I think our listeners are going to really get a tremendous amount of information because there were so many nuggets that I was able to take away from both of you on the criminal side and the civil side. So thank you both so much for carving out, time on, a busy day. Because I know how crazy it is for me. And I know you guys are even crazier with your schedules than I am. So thank you both so much.
No, it was a pleasure. Thanks, Sean.
All right. And to each and every single one of you, thank you as always for tuning in, logging on, and just hanging out with me and my great, awesome guests each and every single day of the week. I cannot tell you how much I appreciate it. We'll be back tomorrow with another episode of The Compliance Guy. So remember, until then, be good to yourself, but more importantly, y'all be good to each other. Take care.